On the memo that the U.S. Border Patrol chief sent to sector chiefs last night allowing for parole releases if overcrowding becomes an issue, that's not Title VIII, like you said, would happen. I mean, these migrants don't get an alien registration number that would be used to track them. They don't get a court date. They're instead asked to self-report to ICE within 60 days. You said at the beginning that you've prepared for this moment for almost 2 years. So why is part of that plan an honor system?
Oh, it is not an honor system. What we do is we use the resources that we have to meet the challenges that we confront. This is a tool that has been used in the past. The vast majority of individuals will indeed be placed in expedited removal, and if they do not qualify, will be removed in a matter of days, if not weeks, from the United States. When we encounter a volume of individuals for which we need to address in a different way, we do so. If those individuals do not honor their commitment to surrender to an Immigration and Customs Enforcement officer to be able to be placed in enforcement proceedings, they are a subject of our apprehension efforts.
You said that it would be a fraction of migrants that this happens with. How many is a fraction when you've had almost 6 million illegal crossings under this administration?
We, last year, removed, returned, and expelled approximately 1.4 million individuals. That is the most in any 1 year.
Will you be on shaky legal ground, though, with mass releases?
Well, first of all,
First of all,
your question has a factual predicate with which I would disagree about mass releases, number one. But releases of individuals subject to immigration enforcement proceedings is not something particular to this administration.
Case-by-case basis, and this would not be on a case-by-case basis.
We implement our operations in conjunction with the Department of Justice, and we have confidence in the lawfulness of our actions.
Okay, go ahead, Jim.
Thank you. Mr. Secretary, are you concerned that the new asylum regulations will encourage more children to leave their families since unaccompanied kids are exempt?
No, we are not. It is an obligation for us to address the needs of unaccompanied children. So we do not have that concern, and what we are driving to, what we are fundamentally driving to, is to build lawful pathways so people do not have to make those difficult decisions, and they don't have to take the dangerous journey in the first place. And we are expanding lawful pathways to an unprecedented degree under the President's leadership.
Mr. Secretary, just one more. What is your assessment of Mexico's enforcement of the border?
We are working very closely with the government of Mexico. The President has spoken with the President of Mexico as recently as earlier this week. They have corresponded last week, and Mexico is taking very important enforcement measures that we greatly appreciate and that were taken in coordination with us.
Yeah, so, Secretary, how is the administration redirecting the immigration judges to prioritize new arrivals, and will that affect the backlog that's already there for previous runs?
So Peter, your question, if I may, just to hit this point once again, your question speaks of an immigration court backlog that exceeds 2 million cases. What a powerful example of a broken immigration system. Not only are we surging asylum officers, about 1,000 asylum officers, to conduct credible fear screenings in the context of expedited removal, but the Department of Justice is surging immigration judges alongside us.
Stephen.
Thanks. Sir, if I could ask you about the...
Sorry, Peter. We're trying to get, sorry, go ahead.
The Title VIII enforcement you're talking about, you're trying to send a message. The critics of the administration would argue this is a message that you could and probably should have sent earlier on in the administration. Can you walk us into the deliberation? How did you arrive at the idea that there should be a presumption of ineligibility, and why was that policy not announced earlier?
So, in response to your precise question, we sought to end Title 42, the Public Health Authority, earlier. We sought to roll out our immigration enforcement authorities under Title VIII of the United States Code earlier. We were enjoined from doing so by a court.
But specifically, the asylum policy, the presumption of inadmissibility. Why not come out with that sooner? You're trying to send that message now. And
It's not a message. We don't promulgate a regulation. We don't promulgate a law to send a message. We promulgate a law to achieve a policy and operational outcome. And the outcome that we seek to achieve through this regulation is to incentivize people to take the lawful pathways and disincentivize them to place their lives in the hands of ruthless smugglers.
It's on the screen behind you as deterrence. New regulation directing migrants.
That's not a message. That's an impact on human behavior.
Okay, we gotta, go ahead. I'll go to the back. Thank you. Thank you, Secretary. First, have you ruled out family detention as an option? And then two, you said that you have many more migrants than you have appointments for. So is there any effort to try to expand the appointments? And do you have numbers for how many appointments are confirmed per day?
So we are indeed expanding the use of CBP One app from approximately 740 arrivals at our ports of entry along the southern border to 1,000 a day. And we are exploring what other capabilities we can add to that. And the first part of your question was family detention. This administration ended family detention in March of 2021.
So you're not going to bring it back at all?
We've made it clear that families who are in immigration enforcement proceedings, including in expedited removal proceedings, a more accelerated immigration enforcement process, will be on alternatives to detention. The conditions of alternatives to detention may be increased as the situation warrants.